In 2006, Ricky Soriano bought a house and lot from a subdivision developer in Cabuyao, Laguna. According to Ricky, he paid the reservation fee. After a month, he paid the equity in full and the move-in fee. Ricky was made to sign a document by the developer's agent, but he was never given a copy of the said document. The only documents that Ricky has are the receipts of the amounts he had paid the developer. He has been following up for a copy of the deed of conditional sale, but was always told that the document is still being processed. One day in 2011, Ricky was and a third person came to their house and told him that he was the rightful owner of the property. When Ricky called the developer's office, he was assured that he has a better right to the property. The developer then requested Ricky to wait for a longer period of time to be given documents regarding the sale for the reason that the title to the property cannot be found. Ricky told the developer that he will wait for the deed of conditional sale and the copy of the title as long as he is assured that the house and lot will definitely be awarded to him since he had spent so much for the improvement thereof. Last November of the current year, Ricky made another follow-up but was told by the developer to leave the property because it is under litigation. While the case is pending, Ricky was told that he is obliged to pay a monthly rent for occupying the property. According to the developer, Ricky is in arrears since the year 2008 and lived in the property without paying a single amount for the monthly amortization. According to Ricky, he cannot be at fault for the arrearages since it was the developer who withheld to give him the deed of conditional sale and copy of the title. Hence, he was not able to process his loan with Pag-ibig for the monthly amortization. Ricky is now asking, what are his remedies since the developer is now asking him to leave the property? What if the title of the property cannot be found? What to the amounts he paid to the developer? And finally, what about the amount he has spent for the improvement of the property? Ricky, it appears that the issue in your case is that of a double sale. There is double sale of a property if there are two or more transactions that constitute a valid sale. The transactions must pertain to the same subject matter. The subject property was bought from the same immediate seller or developer, and there are two or more buyers who are at odds over the rightful ownership of the property, representing conflicting interests. Since you have mentioned that the property is under litigation without telling us the nature of the case concerning your property, we shall be constrained to discuss in general terms the remedies of an individual in case of double sale. The rule of preference, according to the Civil Code of the Philippines, is that preference is given to the person who is the first registrant in good faith or whoever is the first possessor in good faith or the person who can present the oldest title in good faith. Since you mentioned that the title of the property might have been lost and that you don't have any other document that will prove that there was indeed a sale between you and the developer, you might want to explore the remedy based on being the first possessor in good faith. Do get an assistance from a lawyer to assist you in the pending litigation concerning your property. Thank you for your trust in People's Television. Remember, our opinion is based solely on the information you provided us. You are free to consult a lawyer of your choice regarding your legal concerns. Email us at ptv4newscenter@gmail.com. Attorney Jimeno Atienza for the Rule of Law.